Well, welcome to everybody. Thanks for tuning in. I see our number is a little bigger than normal, which is appreciated. Um, we said we were going to talk about 31AA, but instead we're going to talk about the NFC North and what the rankings look like for football. And, and hope for the best on Thanksgiving Day. And what the best is might be different between you, me and most of you. But I see Amy's on here. She's on my side as well. No, we're gonna talk about 31AA. Actually, Brad will probably do most of the talking on it because it is a legal issue, and we'll talk about whatever other issues come up. But as you know from our last webinar 2 months ago, we kind of made a change to try to make the beginning of each of these topical and um, grab issues that are affecting our members that you want to have a conversation about. And so, really, today our thought is to, if you're expecting us to tell you what to do, we're not going to do that. That's not our role, but we will talk about kind of some of the things that you might be thinking or need to think about in the decision. We'll update you on some legal considerations that have really broken the last week, in actually a little bit less than a week's time and give you an opportunity to also share with each other maybe decisions you've made, why you made them. Because I think, when I, even as far back as the conference, because this was already an issue, what I saw at conference was people talking with each other and gaining from each other, just kind of, oh, well, how are you guys thinking about this? And I heard from board, like that was beneficial for board members to just hear what others are doing, what they're thinking, what went into their decision, because I know some of you may have already made that decision. So I'm going to let Brad give you kind of the current setting for 31AA. We've got Jen on as well today. So, she can talk about the legislative side of this and where we're at with the legislature, about any, future change or if there would be one. But let's kind of jump into the conversation. Post questions in the chat so that we have that and we'll kind of pay attention to that and I'll call those out to Brad. But Brad, I'll turn it over to you just to kind of lay of the land on what you've been hearing from districts.
All right. Well, thanks, Don. And yeah, just to reiterate what Don indicated, we're not going to say or give a position of MASB whether or not a school district or board should opt into the 31 AA funds. We believe that is completely a local decision. I know a lot of boards and administrations have been seeking guidance from their retained legal counsel, which is appropriate and being able to go into closed session with that legal opinion from retained legal counsel under section 8H and just to discuss the implications of accepting the 31 AA funds, and that's permitted under the Open Meetings Act. The timeline hasn't changed at this point. We still have November 30th and being the deadline for opting into the funds. And it's important to recognize that this isn't contingent upon a board resolution, whether you're opting in or opting out. But the best practice has been indicated, I think, by most law firms, is that this is a school board decision because it involves waiving the board's attorney-client relationship. When you look at that relationship between an attorney, retained legal counsel, and school district, the board is the client. So because opting in to the funds requires a waiver of that attorney-client privilege, it's the board that must waive that privilege. So that's why it's being categorized kind of as a board decision, but it's not submitting a board resolution opting in or opting out to the Department of Education. That if the board decides to opt in, that directs your administration to follow the process of opting into the 31 AA funds. If the board doesn't approve a resolution or a motion opting in, then by implication that means that the district likely is not opting into those Section 31 AA funds. Um, there is a court case that is pending on the issue. Actually, I should say court cases. A number of school districts have filed claims both in federal court and state court challenging the enforceability of Section 31 AA. There are multiple constitutional claims at the federal level involving due process, that the law is overly broad and doesn't give specific requirements to the participants or school districts who are going to be accepting those funds, based on the requirements that districts are going to be subject to. And there are state claims as well that are going to be argued before the Court of Claims. So you have these two parallel cases, one in state court, one in federal court. MASB has decided to support these cases in the form of filing amicus curiae briefs, in both at the state level and at the federal level, providing the perspective of our members on this issue. I'm assuming, I haven't seen the court documents yet, but I'm assuming there is a motion that would require a stay of the funding, because once the funds are distributed, it's going to be difficult to take those funds back. So my thought is that there going to be a motion for an injunction restricting the distribution of the funds prior to December 30th, so these legal issues can get worked out. And if that injunction isn't granted, things can get very complicated after that point. So that's kind of setting the stage. As Don indicated, the purpose of this webinar is, one, to answer questions, and then two, and probably more so, just so people can share perspectives on what they're hearing at their local level, what's being considered by their board and on this very significant issue. And I think that's why you're here today. You want to hear those perspectives. So on that note, I guess I'll send it back to Don, and we'll go with questions or go with perspectives. So I'll defer to his process here.
Brad, first question is just which federal court? Do you know which federal court it was filed in?
I don't. I'm guessing it's probably the Western District, but I'm not sure. I haven't seen that yet.
Let's just say that we're fortunate enough to get injunctive relief. From a court process standpoint, and I know MASB's represented its members on a number of cases in the past. I mean, I think about this from a timing perspective. We're in November going on to December. Sadly, the school aid budget process will get started again in like 3 months. If we're fortunate, it'll wrap up at the end of June next year. And so, like 7 months from now, like we're going to have a new school aid act, and the legislature would have an opportunity in between now and then to take some action to change this. Like, I have a hard time believing that we'll have any, like that we would have court decisions, not on an injunction, but on an actual case within the next 7 months. Maybe a court of claims, state court of claims, but the rest seem to move a lot slower.
Yeah, I would agree with that. And I don't know if there would be any, retroactive remedy to that, where if districts would receive this funding after the fact, once the merits of the case have been settled. But yeah, certainly there's probably a request to get this on a fast track and a quick decision, both at federal level, at state level. But as you indicated, probably more likely that we would get a quicker decision through the Court of Claims rather than federal district court.
I had heard that they were gonna, like, there's an initial hearing already for tomorrow. Had you heard that yet? Like, I had heard something.
I have not heard that. That would not be surprising. And actually, going back to the initial case of what district, it looks like it is in the Eastern District.
Okay.
Yeah.
Well,
So it is in Eastern District of Michigan, and it's an emergency request emergency relief requested by November 30th, 2025. So,
Well, and my question was based on Shannon's question was, could we expect a court stay or injunction by 11:30? Because if we, I mean, in some ways, I guess damage won't be done by the deadline, but the distribution of funds, as you mentioned, they would be distributed through the state aid payments in December, which will hit districts by 12/20. And so clearly, as you said, like they're going to have a decision on injunction before then. And for districts that are still pending decision, if they can get relief faster, it would stop districts from having to make that decision if they in fact can get an injunction.
yeah, yeah.
So here's a question. Our law firm has advised us that the superintendent could potentially opt in without board approval, regardless of the board's decision. Essentially, he could, quote, go rogue because the opt-in form does not require board approval. Thought on what consequences this action would be?
Well, yeah, I mean, it does not require board approval. Does not require the submission of a board resolution, but it requires a waiver of privilege. And if you know if you have that situation where the administration is acting contrary to the interests of the board, the issue is going to be did the board really waive its privilege? And I guess we won't that wouldn't become an issue until there's a mass casualty event, right? And determine whether that privilege has actually been waived by the client in this situation when there was an opt-in to the funding.
This question might be more to you, Jen, because it's predictions of the legislature, and you're our expert predictor. But if we decline to accept the funds and the requirements change after November 30th, meaning the legislature comes forward and changes the language in the act to something different, will we be able to opt in if the changes are favorable to districts? Because that won't be decided by the courts. They're either going to be like, it's legal, it's not legal, or there's an injunction, or there's not. It's not going to be a change. So, what are your thoughts on a second wave if they change the language?
MD has told us that they have to close the grant period by November 30th because law requires the funds to go out by December 31st. So when they extended to November 30th, that was as far as they felt they could go to still be able to process and put the grants out in time to meet the law. So if nothing changes by November 30th, I would not expect that to reopen. That's where harm comes in that Brad had mentioned, that the money's going to go out. And if the court rules after that, there's not going to be a way to claw that money back and redistribute it. It's going to be distributed out the door. The legislature has gone back and forth with us. I really feel like they were just stringing us along from both chambers. Both chambers were like, yes, we should fix this. And both chambers were like, but we're not going to do it. Someone else has to do it first. So we don't expect anything out of them, which is why the lawsuit was filed so early, that to try to get the relief before November 30th, or the injunction before November 30th. Speaker Hall was quoted in the paper to say, if the court says we have to fix it, then we'll fix it. But I would expect absolutely nothing out of the legislature at this point.
And I would imagine if the courts do, or let's just say the courts languish on this, and so now we're into next April and May, and like there's an opportunity then to try to get legislators to insert language. I mean, our goal from an association standpoint would be make sure that all districts would be included in let's just say there's an injunction that's in place. Our goal would be to get every district access to those funds, again, not be picking and choosing who can and can't.
Right, except that we would be looking at the next fiscal year.
Yeah, right.
Not this fiscal year. So this fiscal year, once the funds go out on December 31st, those funds are gone for this fiscal year. But yeah, as we work on the bill for next fiscal year, we will be working very hard to get that language actually taken out like the House had told us they were going to do this time.
Thanks, Jen. Brad, Elizabeth asked, would we still be able to go into closed session if we had something that was considered a mass casualty event and wanted to discuss future safety implications? And then there's a follow-up, but so they're not doing attorney-client privilege at that point. They're talking about closed session related to student safety and their plans, things like that.
Yeah, there's another closed meeting exception, I believe, is Section 8K, that allows the school board to discuss um, threats to student and staff safety, whether it's a present threat or a future threat. You can go into closed session under a two-thirds roll call vote under that exception. So yeah, that wouldn't have anything to do with waiving privilege. So I would say yes, you could go into closed session to discuss possible future threats to the safety of students and staff.
Once lawsuits like this are filed, Brad, is there any ability for districts to join in after the fact? Or is that closed once it's filed?
It's close. I mean, there's really no need for other districts to join this lawsuit. There's multiple plaintiffs throughout the state, through many school districts. So yeah, it's not necessary for other districts to join. You're not going to be excluded in some way, shape, or form by not being a part of this lawsuit. It's going to apply to the 600 school districts in Michigan, regardless of whether you're a party or not.
Well, and just on that note, I had conversations with this also impacts private school administrators. They're worried about 31A and what it does and so this is not like when Brad said 600 districts, and not that he wasn't wrong in saying that number of public schools, but charter schools are in this, and like there's a lot of people concerned about the outcome of this, not just our traditional public schools and ISDs as well.
Yeah, I'm actually hearing it from the private school side as well, Don. To talk to an attorney the other day who predominantly represents private schools, and they can access the funds, but they have concerns as well, which is understandable because generally they're not subject to the same type of state regulation that traditional public schools are. So they would be going kind of even beyond what public schools would be doing to accept these funds.
And when
Jen?
we put the memo out to the legislature about the changes that were necessary and why, the charter schools and the nonprofit school associations both signed on to that memo.
Thanks for sharing that. Brad, like in your interpretation as it currently stands, let's just say there's no injunction, right? You've made the decision on 31A. Is this a one-time decision? Do they have to go back and do it again next year for the second year of this funding? Or is just a one-time decision?
I see this as a one-time decision for funding for this fiscal year. But what's uncertain is even though it's one time for the funding is one time for this year, it's the requirements to what extent do they apply, and there isn't any language that indicates that you're waiving the privilege for this one year. Likely, you're waiving the privilege in perpetuity. So if the mass casualty event happens 6 years down the road, because you accepted the funds this year, you're likely waiving privilege and agreeing to the investigation based upon the decision you make this year.
Adele, your question's great. And this is a general, could this also happen with future grants? I would say, that is, from my perspective, thinking about it, having lobbied, and I'm sure Jen feels the same way, is once the legislature and or the governor sees success in leveraging a grant to say, here's all, like, there's strings, right? We see strings on grants a lot. This is like a rope on this, not just a string. And I think that if it stands, it won't be because of strings. Strings are allowed, but I think this is a pretty significant issue, and I could really see the legislature and or the governor trying to really leverage how schools act and behave with future grants like this. If they see this as a mechanism that worked this time. I mean, in the past, strings are like you have at-risk funds and you must spend them in appropriate ways. Like that makes sense. This is about real driven change, and I think it does open up the door that we could see more of it. You can't predict the future with the legislature, but it is one where you do have to worry about it.
I think
Um,
the uproar in this, though, is going to temper it a little bit. A lot of this is like the fact that they did this at midnight. Um, and it's so poorly written that there will be some caution before they make strings like this again. And if I can interrupt, I just got a text with an update from the Court of Claims. That the judge has recognized the urgency of the situation, granted a trial for injunctive relief. The key updates are the trial date is December 1st, expected decision on or about December 3rd, and MDE backed up their opt-in deadline to December 4.
Well,
And that
thanks for
that just
hot off
came
the
in
presses.
from some of the lobbyists who were involved in the case.
Appreciate that, Jen. I see a few of you as participants were listing Judge McMillan on Wednesday, state court in front of Judge Patel. Like, so definitely things are moving quickly on this as we wanted. That's why we, as MASB, I was contacted last week to me so that I was made aware that districts were considering the lawsuit. We don't have standing in this situation. We can't be an aggrieved party in a grant that we can't access. And so that's why we are in the place of doing the amicus brief on it as it would be considered a friend of the court to be able to advocate on behalf of our members on a legal basis. And there will also be conversations from ASB as far as helping, schools and others cover costs as this litigation moves forward. Because MASB often helps in that area too. I just wanted to be able to lift that up.
Yeah, clearly, this is an issue the legal trust fund could get involved with, Don. Multiple school districts are involved, members of the legal trust fund. So, yeah, the legal trust fund certainly could provide financial assistance to those districts that are participating in litigation. Because I'm assuming it's not covered by any insurance. This is the school districts footing 100% of the bill.
Yeah, and we may have new board members on here that are just unaware and so the legal trust fund is a fund that is administered through a separate board of directors that are appointed by MASB's board. Brad is the administrator of the trust fund and a legal advisor on that, and districts can apply to that board for assistance in legal matters. Districts pay dues every year to that. The vast majority of districts in the state do participate in the legal trust fund. So clearly, of the 70 plus that are involved, many of them would be current members and would be eligible for that application. And so we will figure that out as that moves forward. But just to give you an idea that this fund, not only for a case like this, but for many other cases, districts have that access and can apply to the legal trust fund for that assistance. Hypothetical question: school accept the funds with a waiver prior to November 30th. Courts and legislature conclude at a later date that the waiver is no longer required. Can the waiver be rescinded?
Yeah, I believe that would be the case. I mean, you would be accepting, the funds and agreeing to that waiver based on a law that the court finds unconstitutional. So because it's unconstitutional, as we hope will be found by the federal court, or unconstitutional based on state grounds based by the Court of Claims, that it would be an unenforceable law at that point.
Thanks, Brad.
Yep.
We were told that the money can't be used on anything existing and it has to be on new initiatives.
Well, that's the rule, that it can't supplant. It's got to supplement. Okay, so you can't supplant a mental health matter or security issue that's currently being funded with general funds. You're supplementing that those initiatives with the 31 AA funds.
To follow up on that question, it really says though, like if they aren't able to, I mean, usually the Department of Ed on applications like this aren't like pulling it saying yes or no immediately, and you would have time to say, here's how I'm going to spend the money. I don't know that would have to be in this initial forum. I just think after the fact, but
yeah, clearly it's after the fact, and there's an accounting that has to be filed
Yes.
after the fact. Yeah.
So I think you will be like you wouldn't likely, as long as you knew what the rules were and you make sure you spend the money appropriately, like most grants, you would end up getting the money. So I don't think that should be a real fear. I know some conversations that I've heard from districts is under the current section, they use that money to fund a portion or all of, say, a school counselor or school social worker. I hadn't heard that differentiation. It's not a supplant thing, it's more of a continuation of current expenses. So if I spent 50 grand on a counselor last year, I'm going to spend 50 grand on a counselor this year. I'm not supplanting anything. That's a new expenditure. Do you think that is okay, Brad?
Yeah, yeah. I think the example is okay. You have a counselor that is currently being 100% paid with general funds. You accept the 31 AA funds and you transfer those general funds somewhere else, and then you pay that
Right.
counselor exclusively with the 31 AA funds. That would be problematic under the law. So, and then this is a consideration, that boards need to be taken into account, looking at, okay, what type of funds are, how are we going to use these funds? And we want to make sure that we're not supplanting, but that, just adding to the cost, to providing these services, or to the adding to the expenses with these funds, and not supplanting.
Hey, Marty, I'm in a Zoom meeting. Can I call you
Other
back?
question. So a district in adopting their resolution limited their opt-in for 25, 26. Do you think that holds legal and that would relate then, of course, to waiving privilege
Yeah,
as opposed to in perpetuity. But do they have that authority? I mean, they might adopt the resolution, but I don't know
right.
if that would work or not.
Well, so it's not going to come into play in terms of getting the funds. I don't think the Department of Ed is going to look into those type of resolutions. It's just going to look into whether the form was properly filled out. Who's ever responsible for doing that. When it would come into play would be if you have a mass casualty event, down the road, 3 or 4 years down the road, and the board says, no, we accepted these funds, but we limited the waiver of our privilege, just to the 25, 26 fiscal year. The state says, no, you can't do that. In accepting the funds, you were waiving that privilege in perpetuity. And then if you don't waive the privilege under the circumstance, you're going to be penalized in some respect. And the thought would be the penalty would be taking away those funds that you received 2 or 3 years ago.
Yeah.
Not sure if that's how it would play out, but that's when that issue would come to a head. Determine if you had a mass casualty event and whether that privilege is waived at that point.
Um, A follow-up. So do you have to pass another resolution rescinding the original resolution? So Adele, I'm not sure if you're saying like, let's say you passed it 2 weeks ago, and if you decided you want to back out now, maybe because of the pending litigation, would you do, and I'm not sure if that's what the question is, but I'm going to go with that. Would you need to do another resolution to back out of that, Brad?
I think that would make sense. Again, resolutions are not required. Okay. What is required is you have an individual, generally the person responsible for submitting these grant applications, and that's the person that's going to be opting in for your district. But the board is essentially authorizing and delegating that responsibility to the administration in passing a resolution. So in order for your administration to know which direction the board wishes to go on this, yeah, I would say if a board wishes to change course, it should pass a motion to rescind that previous resolution if it's contrary to where the board wishes to go at that point.
So almost, Brad, in reverse of our conversation from a couple of questions ago about a district and whether they have a 1 year or whether that applies or not. Question is, what if we opt in, but then don't accept the funds? So now we've got a resolution opting in, don't accept the funds, and then have a casualty event, mass casualty event a couple of years down the road.
I can't imagine that the form permits that. I haven't looked at it. I don't know if I even have access to it, but if you're opting in, I don't think you can opt in and say we're not accepting the funds.
No, the way MD explained it, it's an all or nothing. If you
Yeah.
opt in, you can't get funds if you don't opt in. So you'd have to do it or funds aren't gonna flow.
Once you opt in, they're going to put those funds into the state aid payment and you're going to be in.
Yeah.
More than okay right now.
Can you address the potential, and then I know this came up in one of the attorney letters to districts, having potential of 31A applying to the past?
Yeah, there isn't any limitation either future in the past. So if you accept the funds and if you've had a mass casualty event within the past couple of years, of how that event is defined under the law, the legislature, or excuse me, the governor could initiate an investigation, and then the privileges that you've been kind of relying on in that issue and that matter would likely be waived in that case. Again, that goes to the issue of the law is overly broad. We just don't know the answers to a lot of these issues, these questions, and when you have a law where public entities or individuals don't know how to comply with it, from a constitutional perspective, a lot of times that's overly broad and is contrary to due process.
Yeah, Brad, on that, I actually had a district, actually at our conference, bring that up. They are in the middle of litigation on a school bus accident that they've had. So it wasn't that old ago, or that long ago, because the litigation is ongoing. And their concern was like, if they accepted the funds, it was unclear if it would be retroactive. And so then it becomes their strategy, the conversations related that they've had so far, like, how does that change things if all of a sudden privilege disappears? And that was a big concern for them. Adele, I see you have a hand up.
Yeah, thank you, Don. Just to follow up to what Brad said. So if the court finds it unconstitutional, we pass a resolution to accept the money, do we have to still then pass a resolution to rescind that resolution?
I don't believe so. I think you pass that resolution, and then if the court, whether the Court of Claims or the federal court, finds this law is unconstitutional, it's unenforceable at that point. It cannot be enforced by the Department of Education. It can't be enforced by the governor. So I don't believe a change in the resolution would be necessary. You would just, if you've opted in, you're likely receiving the funds at that point, without being subject to those unconstitutional requirements.
Thanks, Brad. Jen, I don't know if you saw, if you could type the little update that you
Already
gave.
on it.
All right, thank you.
Well, wait, I'm typing two things. One is somebody asked what the mass casualty event definition is, and I'm putting that in writing.
Yeah, the other one is just an update, the things that
the
you said
date.
about the schedule for court cases in.
Yep,
Right.
I will do that next.
All right. And you're correct, and Jen's writing it, but the definition of mass casualty, whether it's vague or not, it's very broad. So like that becomes, I think, as much of the issue as it is a lot of incidences within a school district that most of us, and I think most of our citizens wouldn't think of as mass casualty, would fall under the definition of it. And that becomes a substantial risk for the districts from a legal perspective. Let's see, Amy, I know you mentioned opting in now, could be opting in for the long haul. What do you think the chances are that we will be able to opt in next year if we don't take the money this year? I'm thinking if there's an injunction for this year, we would hopefully have the option to take the money next year without abandoning our privilege. Like, Jen, I mean,
this comes back to what, yeah, this comes back to what shows up in the budget for next year. This is 1-year funding. So if 31AA doesn't include this language next year, you're going to have the opportunity to apply again next year for these funds. It's not an ongoing thing. You have to apply every year. So you're applying for this year. We'll see what the budget says for next year. But the question, and I think it's been raised a couple times, is if you're waiving this privilege, how long does that last?
Yeah. And on that, I think this brings up an opportunity to just talk about process and involvement, right? So I know that this past school aid bill was a bad example of this, and like this was, this bill was passed at the last minute. Our Jen and other lobbyists weren't, allowed, and many legislators weren't even involved in like what it looked like. They just got to vote on it. But for example, if we go into the next budget cycle and language is put in the bill for 31AA, let's say like with similar language, we're clearly we're going to lobby against that. And we're going to reach out to you as members and say, please contact your legislators and tell them that they need to remove this language. And we will we'll probably do something on a webinar as well, but we will depend on you to be able to be there to back Jen and Brenda up as they're in front of the legislature to say, this doesn't work for school districts. Here's a solution that might be different than what you've proposed. So I don't bring it up as like you didn't do it this year because nobody had the opportunity. It was last minute, but I just think it's a place to be able to say, this will likely come up in some form in the budget in the next few months for the following year. And if this language is in there or something similar, we're going to say, call your legislators and we need to get rid of this language or we need to change this language. And we're really going to ask for your involvement and be a part of that. And so, right. I mean, to kind of Jen said it, Amy, it's, if you opt out this year, there's going to be a chance, what do they call it? Another bite at the apple next year to have money put into 31AA, maybe without these strings, and you would be able to get funding for mental health and school safety at that time. Okay, that is being done. So the waiving of privilege, this is only during this new mass casualty event. So the investigation would allow access to any closed session information. But if you don't go into closed session, then the waiver of privilege concern goes away. Or is there another concern? Just trying to get clarification. That's probably to you, Brad.
I wasn't following that either.
So it's really, if you're not going into closed session to use attorney-client privilege during or after a mass casualty event,
right.
Then what's the risk?
Well, I mean, one of the risks is have the chilling effect that it could have on staff members talking with the school district's retained legal counsel on their involvement in a mass casualty event. If I'm a staff member, if I was a teacher and I was aware of this provision and I was, directly or indirectly involved in a mass casualty event, I would get my own legal representative. I would not rely on the district's representative, knowing that I have to waive privilege if I'm talking with the district's legal representative on this matter. So I'm protecting my own legal interests, getting my own attorney. I'm guessing that the waiver of privilege would not apply to my personal communication with my attorney. But again, that could be argued one way or the other. But yeah, it certainly could have a chilling effect on the communications your staff member would have with district legal counsel in trying to represent the district in a mass casualty event.
Well, and I think, Brad, when I think about this from having sat on a board previously, but not having and had been going into closed session with some privilege, not on a mass casualty event, thankfully. But there are times when you're going in, I can't imagine in a mass casualty event that this wouldn't be the case, where your attorney wants to talk to you as the board about potential strategy. They're coming to the board to say, here's what we're thinking. What do you think about that? If you did that in open session, at that point, the litigants that are litigating against you as a district, now you're talking about your court strategy in public, which now you've given them all the tools to beat you. So I just can't imagine a situation where you wouldn't end up in closed session to talk strategy with your attorneys.
Well, that's a different exception, Don. So let's not confuse attorney-client privilege with the pending litigation exception. So in that
Okay.
case, if you are involved in litigation, so let's say there is a mass casualty event
Yep.
and you have been sued as a result of that mass casualty event, and you have the investigation going on with that's been initiated by the governor, you could still go into closed session under the pending litigation exception, as long as your attorney is present with the board and you're discussing litigation strategy with the board. And it's a 2/3 vote to go into closed session. And you could show that having open communications about the pending litigation would have a detrimental effect on your litigation strategy. So you could still go into closed session under that. But if there's no pending litigation, then you could not go into closed session based on the attorney-client privilege if you've waived your privilege relating to that mass casualty event.
Yeah. Good clarification. I mean, I don't know that you'd ever have not even a any casualty event at a district, like it almost always results in litigation. And then you have to get a clarification of which one I can go into session for this, but not in this situation. And I see it adding to the confusion that we're talking about here.
Yes.
Are there suggested items that we can attach to the opt-in? I think you've addressed that. Like, it's really the form you're filling out, not the resolution you're passing. And if you're accepting the funds, you can't really put limitations on it through your resolution.
I agree with that.
If the resolutions are not required, why are legal firms recommending that we adopt a resolution, whether to accept, decline, or decline with the option to change our minds if the law changes?
Ultimately, because the board is the client. If you're waiving the attorney-client privilege in a relationship between the district's retained legal counsel and district legal counsel, or the district and the district's retained legal counsel, that privilege can only be waived by the board, and that's why you should have a board decision on opting into this, and the board fully waiving the privilege as required by law.
Yasmin brought back her question. It says, they were told that the money can't be used on anything existing, which you've addressed, has to be on new initiatives. And we have to show how we will maintain the funds in our next year's budget, apparently through the application process. So if we don't have that plan, they could deny the application, meaning even if we do waive our attorney-client privilege, they might still be denied the funds.
My thought would be you would only, if you don't get the funds, you're not waiving your privilege. I think it's the two are tied together. That's just my initial thought. I can't imagine that if you didn't get the funds and you opted in, that you would still be subject to the requirements.
And I'm going to clarify, and I know you do when you do individual conversations, Brad, right? Like Brad's doing his best to give his thoughts on where this is at. If you're looking like really trying to, about to make the decision, I mean, it is appropriate. You need to turn to your retainer firm and be like, hey, like, can you get more clarification? So Yasmin, your question, like, get as much clarification from your retained firm on that question so that you're making the decision that you think is appropriate for your district. Because ultimately they're the ones that are going to defend your decision if you end up in future litigation.
And my thought is that the only entity that could answer that would be the Department of Ed, and I'm not sure if they're willing to answer that.
Jessica's asking a question that I'm going to answer for you, because she's asking whether they should opt in or not. And he said it at the top of this, like, clearly, MASB, like, we are fighting on your behalf in the legal side of things. We do not like the language as it was included, but we also don't feel comfortable, just as many of the law firms, like making the decision for a district because and I've talked to a lot of superintendents over the last 3 weeks about this. It does really come down to many things, right? And I know Yasmin's had the questions about how you spend the money, but I know a lot of people are interpreting this and saying, well, I've been spending this money on a school counselor or social worker or a school safety person. And if I don't accept the funds, I might have to lay that person off. Or I've got to spend general fund money and make sure that the board understands that opting out means that we're going to spend down fund balance. Those are all decisions that the board and the superintendent need to take into consideration when you're making the decision against what am I losing if I opt in and we don't know what this looks like for attorney-client privilege, and as it goes backwards, is it forwards for how many years? I was talking to a reporter last week about this, who I felt really was trying to get a good feel for what are boards having to think about when they go through this. And I did point out, and I said, well, if a board makes a decision, to opt in, they receive, let's just say, $100,000 is what the grant is, and it's interpreted that this lasts into perpetuity. How that impacts a case 4 years from now, and whether you are able to go through a process of a mass casualty event and protect things that could end up like, even if it's a investigation, what happens with that information later? Does that help trial attorneys that are suing you? Do you end up taking 100,000 this year but losing 3 million in a litigation later? I mean, there's lots of things to consider, and MASB is just not in a place, and Brad as an individual, to be able to say, do this or do that. It is, I mean, I don't begrudge a district that says, based on our need, we're opting in. I also understand fully why a district would say this doesn't make sense for us. The risk is too large. And so I know that's not what you wanted to hear, Jessica. You probably would like clear direction, but it will vary for district to district. For some, the grant amount is maybe substantial, maybe their fund balance is low. For others, they're like, we've got a decent fund balance. We can continue to fund this position for a couple of years. We're not going to take the risk, and we're going to hope the legislature or the courts are going to deal with this. So it's just, it's a tough place. So.
Hey, Don, I noticed Stan had the comment about ex post facto applying here, and
I missed that.
Yeah, what that means is applying a law retroactively. So, the legislature implements a law saying you can't do this, and a year ago you did that. Can law enforcement go back and say, okay, we're enforcing this law retroactively, what you did a year ago? And no, that violates due process. Due process is all about notice. And are you put on notice that what you're doing is illegal or wrong or in violation of the law? And again, that goes back to one of the arguments being made in the court filings, that is that this law violates due process because we don't know, we don't have notice as far as whether it does go back retroactively or not. And if it does in fact, then it may violate due process from that perspective as well. So yeah, that's a good point, Stan. It would likely be contrary to the ex post facto clause of our Constitution, but that's another issue that's going to be settled in court.
I see. Does this waiver, like if we're dealing with this as an investigation, Brad, does this waiver include waiving privilege for all confidentiality of teacher, counselor / student conversations?
So it does say all privileges. Okay. So it would encompass any privilege that applies to the investigation. However, it would not require the disclosure of what could constitute an education record under FERPA. Okay. There are no built-in waivers to disclosing education records. So likely a confidential communication involving a student and a staff member that's been documented, that would likely fall under FERPA, and it would be a protected education record, not subject to disclosure.
Jen, I think I know the answer, but you can correct me if I'm wrong. As schools opt out, the remaining funds get distributed at a larger level to each district that opts in. Am I correct?
That's my understanding, because all of the money in the pot has to be distributed by law. So they wouldn't be able to decide they're only going to do X number of dollars, because then there would still be money in the pot. They'd be violating the law.
So kind of in reverse of where it's prorated when there's not enough money. In this case, districts would get more if they were opting in, but it's hard. You can't tell what the dollar amount is until you get to that point. Excellent news on December 4th. Elizabeth's question, even though insurance companies have said they would cover districts that opt in, isn't there still a risk that insurance later declines to cover a specific situation because they deem the district to be at fault? So I'm going to step out on a limb, Elizabeth, and hope that I don't have it cut off from me. I will speak to this. I can't speak for a district that is got a private insurer that is working with them. But I will say I know from my perspective, because years ago MASB helped create SETSEG, which the vast majority of you have for property casualty insurance, which this would fall under. That is not a private insurance company. It is a pool of all of the districts of the state of Michigan coming together, and it's a self-insurance pool. It is not a private entity. And the people that sit on that board are superintendents, association executive directors. So it is us, right? It is the membership that sits on those boards. And I will say all of the decisions as it relates to coverage are made. They try to make them like it's not like the board decision, just like you locally don't make all the decisions. I don't either, but it is meant in the best interest of the pool. And so I think that that's the kind of question that if a decision was to be made by SETSEG anyways, they're going to come to the board and say, what do we think about this? And at that point, it's precedent setting for every district that's in the pool. And so I know that SETSEG has said, we're going to still cover you in this situation. And I've been in meetings where they've said that. And I still feel comfortable in that space. And I will say in the past, districts have been found at fault in different situations, and the insurance still covers them. It doesn't, that it isn't insurance is like it's a car accident, right? Like you get in a car accident and you ran a red light, your insurance still covers you. You just end up paying a higher premium after that. And so I appreciate the question, but I really think that in large part, at least the largest insurer pool in the state has committed to saying you'd be covered. And there are circumstances that maybe I don't know in the future and can't see those, but because it's a pool of all of us, I think you have a much better chance of not having a problem than I don't know how a private insurer would act. Wow, and I know we're almost at the time, and not surprising that it took this long. Could you please clarify the usage of the money? Can it be used to pay salaries, or should it be supplemental usages? Amy, in that situation, goes back, right? This is a decision that a local district makes whenever they get grant funding. There is not a limitation. You can use it for salaries. You can use it for items. The question really is to you as a district, do you use grant money that could be considered one time, even though this has been around for more than 1 year? Do you use it on salaries and take the risk that the legislature doesn't fund it a year from now, and therefore now you have to maybe lay off or pay for that person out of general fund? That's not a current language question. That's a question that we always deal with when you have grant funding. I mean, we can say 31A, which is not AA, but the actual main section is at-risk funding. That's been around, and that's a formula grant. It's been around for years. You can feel pretty comfortable that you're going to get that from year to year, and you can use it to fund staff. These more short-term and new grants, I know MASB and MSBO often recommend in their early years, you might think about equipment and other things before you move into the staff space, because it is so up in the air whether they will be continuing to be funded or not. So we advocate at MASB for more school safety and mental health money every year, but it doesn't mean that it will happen. So good question, but again, one that a district makes that decision. Also looking for clear if counselor, SRO, et cetera, salaries have been paid from expiring grants, not the general fund. Can 31AA funds be used to pay salaries going forward? That was the question I had to you, Brad. Like, you paid for it before with money, you're going to continue to pay that. Like, my understanding, and I think you said the same thing, like, that's not supplanting anything. You're just, that's an ongoing expenditure. my initial thought was that you could use it for that. I don't know that I've seen anything different. Jen, I don't know if you've seen any or heard anything on differently than that either.
I'm sorry, I was answering a text on what?
Uh, this is that question. So if we paid for a counselor out of this section last year, now we decide we're opting in, we get the money for this year. My understanding is if you're not supplanting out of your general fund,
Right.
you can continue to fund that position, even though it's not a new item, but it is a new expenditure.
Right. I think what MD is saying is if you're paying for a staff out of your general fund, you can't switch it.
Yes.
But if you're paying for the staff out of 31AA, that can continue. That's what they're trying to get at is you can't shift current staff into 31AA dollars.
Brad, do you think that the districts who opt in will become targets of ambulance chaser attorneys?
Well, I mean, anytime, I think Don mentioned this, anytime you have a mass casualty event, there's likely going to be litigation. Certainly, if you've opted in to receiving the funds and you have that event, I think a district will be put at a disadvantage in terms of being subject to plaintiff litigation. And the plaintiffs will likely have access to more information, or the district will be in probably a more difficult position, knowing that there will not be an attorney-client privilege to rely on, and that certainly could impact the way a district works with its retained legal counsel in defending that case. So.
Well, I can see like we've got more questions. We're at 1 o'clock already, and we've got more questions, and I'm scanning through them quickly. One that I think has not been asked in any form. Let's just say that this stands as it currently is. Board opts in, gets the money. Next year's School Aid Act changes, and this requirement isn't there. Brad, do you think because of this lack of clarity about forever, like they've accepted the money in this year, they opted in, they might be waiving attorney-client privilege, even if next year's pot of money doesn't have that same string attached?
I would agree, and unless the law, the State Aid Act going forward, addresses that issue specifically. But if not, if the language is just different and doesn't address, funds that were received in the 25-26 fiscal year and being subject to those requirements, even if the law changes, I would think that still you could be subject to the requirements that you agreed to this fiscal year.
Thank you. I'm looking as we just go through, and I know we're getting as I said, we're at 1 o'clock. If we could get an updated Q&A or FAQ sent out to districts, that would be much appreciated. I don't know what that looks like because the legal landscape's changing so much with these court cases, and I know districts are still trying to figure out like what decisions
districts
to make.
will receive guidance from the retained legal counsel on that, Don. All the major law firms, Miller Canfield, Miller Johnson, Troon, all sent memos
Clark
to
Hill,
your districts, and any updates they will send out updated memos.
Yeah, and I think that's the best place to go rather than us, just because our guidance, and Brad's been doing it forever and we count on him, but at the end, it is about who represents you in court, and it is those retained firms. Jen just posted federal court is scheduled a hearing on November 19th to set timelines. So this is
It's a
moving fast.
lawyer, it's just a lawyer meeting, but it's the first step for federal court.
Can you please share this video for us to look back on? Larissa, do we keep the Member Matters webinars for people to
Yes,
watch?
they are available on our website, so it should be
All right.
available this week.
Very good. Well, everybody, thank you very much for showing up. I'm glad that we were able to answer questions as much as we could, but appreciate Brad and Jen's time on this. They've been in this mix, Jen going back months, and Brad, at least in the last month on this issue, has taken up a lot of time. Thank you all for the work that you're doing. I know this has not made your jobs easier, but you are doing great things for your kids, and whatever decision you make is the right decision for you as a school district. So just keep that in mind as you're going through this. It is different for everybody, but thank you very much for what you're doing, and have a good afternoon.